Hi, I am Michael Santos with Prison Professors, and what we strive to do all the time is help people who are going into the criminal justice system understand topics that will help them have a better experience. And today, we are going to be providing some information on the CARES Act. Now, the CARES Act has authorized the director of the Bureau of Prisons to have more authority when it comes to transitioning somebody from a prison to home confinement. And that's a big deal. It's really kind of historically unprecedented because in the past, the Bureau of Prisons really focused a lot on keeping people in prison, not bringing them to the community at the earliest possible time. Of course, the pandemic changed things in the country. When that happened, the president gave authority to many government leaders under the CARES Act, including the Attorney General, and the Attorney General then passed that discretion on to the Director of the Bureau of Prisons, authorizing the Director of the Bureau of Prisons to let people go home or go to home confinement to serve their sentence on home confinement at an earlier date. Now, in a previous episode, I provided an interview that we did with the Director of the Bureau of Prisons, the former director of the Bureau of Prisons, who implemented the First Step Act and was in place, I think, at the time that the CARES Act, yes, and he wasn't also in place at the time that the Bureau of Prisons had more authority under the CARES Act. And the Bureau of Prisons published a series of memorandums with guidelines, and those guidelines could mean that the Bureau of Prisons would direct case manager staff to send people to home confinement that were qualified, provided they met certain criteria, much earlier than they otherwise would have gone. For example, they could have gone at 25%, but if their sentence was a certain length, they would qualify at 20 after they've served 25% of their sentence. For others, it was after they'd served 50%. Now, that's significantly lower than existed in the past, and that policy is still in place today. But those memorandums were only guidelines. An individual could apply to the judge or to the Bureau of Prisons even for special consideration outside of those guidelines in a special case. When that happens, however, the discretion leaves the institution, the local institution, and it goes to a special division in Washington, D.C. Well, today what I'd like to do is help people understand the risks of asking for a special consideration outside. And what I'm going to do is I'm going to read from a request that an individual had who was serving a 21-month sentence. And while he was serving that sentence, he had specific conditions that would have advanced him as a viable candidate for special consideration outside of the guidelines. So the first month that he was there, the second month that he was there, it made no sense for him to be inside of a prison. It should have been on home confinement. And based on the advice of counsel, he provided an application for a special request. Well, the Bureau of Prisons didn't authorize that special request. In fact, they denied it. And what I'm going to do today is I'm going to give you the follow-up of what happened after that denial. So remember, the backstory is that at the start of the journey, the individual would have qualified normally at the local institution at the 25% mark, meaning on a 21-month sentence, he would have served roughly 5 months, right? 5 months. Maybe worst case 6 by the time the way the bureaucracy worked, 5 or 6 months on a 21-month sentence. And ordinarily, that some people would say that's a pretty good situation, but this person had special conditions. And I'm not going to reveal the individual, and I had to because I want to share this with people in prison, I've taken out all identifying information, and you'll notice that as I read through this document. But the important salient point here is to understand what the Bureau of Prisons, how they are going to respond when somebody asks for a special request, particularly when the individual could have a higher profile that brings a spotlight onto the individual. So it's important to consider these factors when making a special request for CARES Act consideration. When that happens, again, it leaves the discretion of the local institution and it goes to Washington, D.C. to a special division. unfortunately, as you're going to see, when that special division makes a decision, then if that decision is negative, if it's positive, great, the person goes home early. And there are people that get it, okay? There are people that get it. But if you advance that policy and the central office says no, well, then when it goes back to the local institution at the 25% mark, that authority is going to remain in DC to take a look. And you're going to see what happened to this individual. So it's a very difficult decision for anybody to make, and we never try to make that decision for anybody, but we do like to provide as much information for people so that when they are kind of assessing what to do, they say, okay, I'm playing, I understand the risks, the rewards, and I can make a more informed decision. So let me go ahead and read this document to you, and you can find it. By the way, I make these programs available in every format: audio, video, text-based. But on the Prison Professor's website, if you go to the advocacy section, you can see a lot of this information for free. And I would encourage you to educate yourself and learn so that you could be your own best advocate. That's what we try to provide for people. Information that you can use to navigate your way through the labyrinthine, difficulties and challenges of living in a big bureaucracy. And the more you know, the better the position you are going to be in. If you don't know, you just think that the Bureau of Prisons is always going to exercise the will of Congress. But I think that if you look at that interview we did with the former director, that may be the intent of the leaders of the institution, but it's a huge bureaucracy, and there are 36,000 people working in that bureaucracy. And those 36,000 people don't always, it's very difficult to retrain them. For decades, as I've written in other areas, for decades, those people have really been trained to say no and to keep people locked in the prison system. And now all of a sudden we have massive prison reform legislation that really tasks them when thinking about the individual and the individual's families and getting that person ready for society. That wasn't part of the mandate when I served 26 years in prison, but it is today. And for that reason, every individual needs to learn the power of self-advocacy and learn to make decisions from a principled position. And that's what our team strives to do. You don't have to pay anything if you're on the Prison Professor's website. Everything that other consultants use that you can sell, you can get for free right here, but you've got to do the work and you've got to have the benefit of all the information. And that's what we strive to provide. There's a lot of it, and it's kind of like I could give you, I could give you the Microsoft playbook, but that doesn't mean you could build Microsoft, right? But you do have the information right here, and I'm going to share it with you right now. So now let me turn to this other little nifty cool thing I can do on my computer. So I could turn to the area. As you can see on the blog page itself, you will see the article. We're always publishing new articles there. And this is the one that I'm going to be reading from, called The Special Case. So I'm going to pull that up, and I hope that I will be able to find the documents there. So yeah, when I pull them up, let me see, I'm gonna have to make some adjustment on my computer screen before I start reading so that you could read along with me if you're watching this on a computer. So let me try to make this a little bit bigger now so that you could find it, because a lot of the people that we communicate information to, they are inside of a jail or a prison, and we try to give them as much information that they can possibly have to get the best outcome. That's really what we do. Regardless if a person has financial resources, we want them to learn how to advocate for themselves. So I've blacked out the information, and because otherwise it can't get into the Bureau of Prisons. They're very sensitive about ever identifying a staff member, ever identifying an individual, ever identifying, all kinds of stuff. So out of an abundance of caution, I have blacked out, and to protect people's identities, I've blacked out anything that would indicate who somebody is. And the first thing I need to do is read the actual, it's this one here. This is what I'm going to be reading right here is a very high-powered law firm's response to the acting general counsel in the central office of the Bureau of Prisons. You can see that although I've blocked it out, that's who this was addressed to, okay? So let me go ahead and start reading. Dear Mr. Blank, and then there's the individual's name, Blank. I'm just going to call him Mr. Blank. Mr. Blank is the general counsel, and then now we're going to talk about the subject. Mr. Blank fits squarely within the class of offenders the Attorney General and BOP Director directed to be transferred pursuant to the CARES Act to serve the remainder of their sentence on home confinement to mitigate the spread of COVID-19. Although both the facility warden and the relevant RRM, that's the residential reentry manager, agreed with this assessment, the Correctional Programs Division in the central office, so that's a specified division in the central office of the BOP, refused to change the Century Code entered after the previous denial, which is determinative of whether the offender in question satisfies the Attorney General's and the BOP Director's stated criteria. According to CPD, the Correctional Program Division, Mr. Blank was denied because the court, at sentencing, found that he had a supervisory role in the offense and obstructive justice. This refusal is wrong for several reasons. Now, let me just kind of break that paragraph down. Remember, Mr. Blank had a 21-month sentence. Mr. Blank surrendered to prison. Mr. Blank filed a request to go to home confinement as a special circumstance. The Bureau of Prisons then at the institution elevated that special request to the program division in Washington, D.C. And now, all of a sudden, the Washington, D.C. division is looking at this individual. And when they're looking at this individual, who happens to be a high-profile individual, they made an assessment that said, no, he's not going to be a special condition. And so now what we're doing is we're looking at how did the law firm respond. So let's continue. First and foremost, the stated reasons are inconsistent with the most recent BOP memorandum discussed below, which reserves the denial, Century Code, for those who fall outside the BOP's stated criteria. The Century Code, for those of you who don't know, is a computer system that the Bureau of Prisons uses. It's like their database, and they gave him the reason for the denial in that Century Code. And the lawyer is objecting, stating that the reasons that they give is outside of the scope of what the Attorney General recommended and what the BOP recommended in its memorandum. I know this is confusing, and I'm doing the best that I can to break it down. Now, neither a defendant's role in the offense nor a guideline adjustment for obstruction of justice is listed in this BOP memo as being among those factors that are disqualifying. So what does that mean? Remember, I told you that the BOP issued a memorandum indicating who should be considered for transitions to home confinement. And in that memorandum, they listed specific conditions, but obstruction of justice was not in there. Okay, so that's what the lawyer is arguing. Second, once an inmate has served 25% of his sentence, and I hate the word inmate because he's really just a human being. So once the individual, but we'll go with what the vernacular of this lawyer. Second, once an inmate has served 25% of his sentence and is otherwise qualified for release, the decision is the warden's to make, and the warden's discretion should not be preempted by a decision of CPD made prior to the time the inmate was fully qualified. This is the salient point here, okay? The individual tried to get a special case exception. That got elevated to the central office. The central office said, no, this isn't a special case. And then the individual got to this threshold point where it would not be a special condition. He would just be eligible for release at 25%. The warden recommended him. The person had a date. But then central office went in and rejected that date and pulled it. And now the individual didn't get out at the 25% mark, which is what he could have done. So had he only had gone through this process and not asked for a special condition, he very likely would have gotten the release at the 25% because it just would have been a local decision. But instead, he got the people in Washington involved, and that caused a problem because then when the warden did authorize him at 25%, well, the CPD, the Correctional Program Division said no. So let's continue. Third, similarly situated offenders are eligible for other forms of early release pursuant to BOP regulations, namely RDAP and FSA. That's earned time. For this reason, for the reasons that follow, the Century Code for denying blank release should be deleted to permit the warden, in conjunction with the facility staff and the RRM, to exercise their discretion and transfer Mr. Blank to home confinement, both to protect the individual and to mitigate the spread of COVID-19 at the FCI. And that's kind of a problem, but whatever. Okay, so that's important to understand. What happened here? Well, the warden, remember, the policy stated that he had a 21-month sentence. On that 21-month sentence, he could have served 25% and likely been transitioned to home confinement. That would have been about roughly 5 months, a little more than 5 months. But at 2 months, he tried to get a special condition. That special condition went to the central office. Central office now has their eyes on him, and they said no. And now the warden later tried to do it, but there's a Century Code that required it to go back to kick it back to the central office, and the central office then overruled the warden at the 25%. So here the lawyer continues. They're describing why he meets the criteria for CARES Act relief. Both the warden and the RRM, that's the residential reentry manager, and we wrote about that in another video that we did with it's on our subject matter expert page. I encourage you to watch those videos with the director and the former head of all residential reentry centers across the country. So both the warden and the RRM concluded that Mr. Blank met the BOP criteria for home confinement. They were correct. The most recent BOP guidance of relevance was issued April the 13th, 2021 by the Assistant Director of Correctional Programs Division, the memorandum. Now, the memorandum provides updated guidance and direction and supersedes the memorandum dated November 16th. So they're giving these specific memorandums. All of those are available on our website. Rather than providing a non-exhaustive list of criteria, the memo explicitly states that the following factors are to be assessed to ensure inmates are suitable for home confinement under the CARES Act. And here are that bullet point list. Reviewing the inmate's institutional disciplinary history for the last 12 months. That's why it's so important to avoid disciplinary infractions, right? Opportunities open, but if you've got a bad disciplinary record, you don't qualify for these opportunities. Inmates who have received a 300 or 400 series incident report in the past 12 months may be referred for placement on home confinement, if, in the warden's judgment, such placement does not create an undue risk to the community. So, a lot of discretion given to the warden. Number 2, ensuring the inmate has a verifiable release plan. Another reason that it's so important to document your journey. 3, verifying the inmate's current or a prior offense is not violent, a sex offense, or a terrorism related. Those are exclusionary resents. Remember, the inmate's current or prior offense is not violent, a sex offense, or terrorism related. So it's important to do an assessment on the offense and the prior background. Next, confirming the inmate does not have a current detainer. If a person has a detainer, it's very important for the individual to work toward removing that detainer. Ensuring the inmate is low or minimum security. Okay, so that's important as well. You want to get your disciplinary infractions away and participate in programs so that you can hopefully move to lower security levels. Next, ensuring the inmate has a low or minimum pattern recidivism risk score. There are dynamic factors that influence the pattern score, and it's crucial that every person learns and understands them. And we have information on how to do that. Next, ensuring the inmate has not engaged in violent or gang-related activity while incarcerated. Now, this must be reviewed by the SIS. That's the FBI in every BOP, the Special Investigative Services Unit of the Custody Department. Next, reviewing the COVID-19 vulnerability of the inmate in accordance with CDC guidelines. So very important that you understand the COVID vulnerabilities, right? Next, confirming the inmate has served 50% or more of their sentence, okay? So if you have 10 years, did you serve 5 years of that sentence? Or has 18 months or less remaining on their sentence and has served 25% or more of their sentence. So that's crucial as well. So if you've got 18 months or less remaining and you serve 25%, you qualified. What does that mean in practical terms? Let's say that you have a 5-year sentence, okay? Hypothetically. And on that 5-year sentence, you get good time, all of it. That's 15%. So that takes off, on 60, so that takes off 9 months. That takes you to 51 months, okay? Now let's say that, let's leave RDAP, let's take RDAP out of it as well. So you participated in RDAP and you got 12 months off of that. So 51 minus 12, that takes you to 41 minus 2, that's 39 months remaining, okay? 39 months to serve. And let's say that you got 6 months of First Step Act credits. That takes you down again. So now you're at like 24 months. Well, 25% of that time is only, 6 months. So it's on a 5-year sentence at 6 months if you have less than 18 months to serve. So you got to get, there's like so many complexities to this equation. But at the end of the day, on a 5-year sentence, it's theoretically possible that you're going to serve less than 2 years. Theoretically. A lot of the stars have to be in alignment, but it's certainly possible given this memorandum. And so that's kind of what we have here. So see Exhibit A of the Matavusian memo at 1-2. So it is undisputed that Mr. Blank fits this criterion. Again, you can see that memorandum on our website. He has no disciplinary infractions of any kind. Okay? Next, he has a verifiable release plan. Next, he has no prior offenses and his current offense does not involve violence, sex, or terrorism. Next, he is a minimum security person. Next, his pattern score is minimum. Next, he has no ties to gangs, nor has he engaged in any gang-related activity. Next, he has 7 comorbidities, right? He's got a lot of this information here that's helpful, and you want to document that. Next, he has less than 18 months remaining on his sentence, for which he has thus far served 25%. So a lot of favorable criteria there. Additionally, Mr. Blank was at liberty on bail on this case without issue for 3 years, and 2 months this period included bail pending appeal. Mr. Blank was also permitted to self-surrender, which he did without issue. There is no reason to believe, therefore, that Mr. Blank poses any risk to the community if transferred to home confinement, the same place he resided during the pendency of his trial and appeal. The Warden and the RRM's division decision to transfer Mr. Blank was consistent with the BOP guidance. Remember, the Warden agreed he's qualified. The Warden submitted him for this placement. Then the Correctional Program Division blocked it because he applied for early termination earlier. So now the lawyer is going to get into some legal talk about why the Correctional Program Division erred in overruling the warden's decision. Per the memorandum, the warden may forward the home confinement referral to the Correctional Program Division for further review. If the warden determines there is a need to refer an inmate for placement in the community due to COVID risk factors who is outside of the criteria listed above. Exhibit A at 3. Clear from this language is that the decision, and that Exhibit A would be the memorandums that we're talking about. Clear from this language is that the decision whether to grant release to these people who satisfy the factors listed in the memorandum belong to the warden, who engages the CPD only to seek review of an application on behalf of an inmate whose circumstances do not satisfy the memorandum criteria. Although the initial entry was made by the CPD at a time when Mr. Blank had not yet met the criterion of having served 25% of his sentence, he logically should be in no worse position after he meets the criterion, and the warden's authority to evaluate his suitability for release pursuant to the memorandum should be unencumbered by the CPD. which, consistent with the warden's authority, should delete the prior entry. Now, support for the conclusion is provided in part by the memorandum that states, if an inmate does not qualify for CARES Act home confinement under the above criteria, they should be reviewed at the appropriate time for placement in a residential reentry center and or home confinement, consistent with applicable laws and BOP policies. Exhibit A, and then there's the memorandum at 3, and with the emphasis. Clear, therefore, is that the denial of the censure code is applicable only where the warden believes the offender is ineligible under the applicable criteria. Indeed, when the appropriate time arrives, whenever the offender fits the criteria, the memorandum instructs that the offender should be reviewed in conjunction with the applicable factors and the warden permitted to forward the request to the RRM, the residential reentry manager, for a final determination, because that's the person who makes the final determination, as would normally occur if any other person the warden denies eligible. Very confusing to people, but I'm providing you the guidance here to make your own decision. Here, when Mr. Blank first applied to the warden in blank, his application consistent with the memorandum was forwarded to the Correctional Programs Division in the central office because Mr. Blank had not served 25% of his sentence. But he was denied. The CPD denied the request without providing a reason. When the only impediment to Mr. Blank fitting within the appropriate, the memorandum criteria was removed, the time was appropriate for the warden to send the recommendation directly to the RRM, which he did on or about this date. Agreeing with the warden, the RRM on this date approved the person to home confinement and advised that he would be transferred. So they gave him a date. You are going home. But then 2 days later, that Mr. Blank got the bad news because he was informed that his release had been revoked by CPD. Now that's the salient point I want you to see. They told Mr. Blank that the basis for the revocation was the initial March 4th CPD denial before Mr. Blank had reached his 25% served. Had he never applied, it never would have went to CPD. It would have been a simple thing. He would have gone home. A review of the March 4th denial signed by Mr. Blank states that the CPD believes Mr. Blank is ineligible under the CARES Act due to his role as an organized leader of obstruction of justice, percentage of time served, never before. That's not a viable factor in the memorandums, but let's continue. Now, here's the footnotes. Our understanding is that because Mr. Blank, at the time of his initial application, had not yet served 25% of his 21-month sentence, the warden submitted him for consideration to the CPD due to his numerous health conditions. Okay? The CPD's claim that is that all we got on that footnote? Yeah. So we're going to continue with the main letter now. The CPD's claim that the percentage of time served is never a factor is inconsistent with the memorandum criteria that the inmate has served 50% or more of their sentence or has 18 months or less remaining on their sentence or 25% of their sentence. More fundamentally, the memorandum requires verification that the inmate's current or a prior offense is not violent, a sex offense, or terrorism related, and therefore would require a warden to refer an otherwise eligible person to CPD, but does not require such a referral for inmates convicted of any other offense, nor does it exclude inmates where sentencing guidelines reflect any particular adjustment, such as his role for the offense of the obstruction of justice. Further, other high-profile people have been transferred to home confinement after having committed far more egregious offenses with similar enhancements. For example, and then they cite a 69-year-old former comptroller who was serving a 22-year sentence. Over 22 years, she embezzled more than $50 million to live lavishly, and that person got released. Okay. And likewise, a 73-year-old former person of significant was transferred to home confinement, notwithstanding that she had been sentenced to 5 years imprisonment for stealing nearly $1 million from other people. And, we're giving the cases in here, but I don't want to read them because this goes into prisons and I don't want the warden to stop it from going in because I'm giving this information away. I just want you to have this information to understand what's going on here. And so to summarize all of this, The bottom line story is, and you can read it all here. I'm still scrolling through it. If you want to see the backstory, I encourage you, go to Prison Professors, look into the advocacy tab for the article that I spoke about on Director of the CARES Act. And you can see the whole thing. It's rather lengthy memorandum. I did try to redact everything, but I'm showing it there on the YouTube channel by just scrolling through that entire legal position. And then, because I want to turn now to the Bureau of Prisons response, and I've already been speaking for 30 minutes. So I think that you get the summary of this entire process. The person would have qualified at 25%. He tried to get a special provision, and that elevated the issue to the what do you call it? The Bureau of Prisons division in Washington, D.C., and that resulted in another problem for him. So he had a date to go home, and then they pulled it. And now we're going to read from that memorandum, which is from the General Counsel's office in Washington, D.C. So it says, now they're writing to the lawyer who is representing the person in prison. Your letter addressed to blank, General Counsel, Federal Bureau of Prisons, has been forwarded to me for response. You claim the recent decision by the Program Division to deny home confinement for inmate blank is inconsistent with the guidance set forth by the United States Attorney General and the Director of the Bureau of Prisons. You indicate that the warden at the FCI, in conjunction with his staff and the respective residential reentry manager, should be permitted to exercise discretion and transfer Mr. Blank to home confinement, both to protect Mr. Blank and to mitigate the spread of COVID. Now we're going to get into some BOP talk. Pursuant to the authority granted by the Attorney General under the CARES Act and consistent with the guidance provided by the Attorney General, in a memorandum dated March of 20, prioritization of home confinement as appropriate in response to COVID pandemic, Mr. Blank was recently assessed for placement on home confinement as a result of the COVID-19 pandemic. Following a thorough review, he was denied home confinement by the Programs Division on March the 4th. In assessing Mr. Blank's suitability for home confinement, numerous factors were taken into consideration. While non-exhaustive, some of the factors reviewed in this case involved the inmate's age, his vulnerability to COVID, the security level of the facility where the inmate is located, the inmate's conduct in prison, the inmate's pattern score, whether the inmate has a demonstrated and verifiable release plan, the inmate's crime of conviction, and an assessment of the danger posed by the inmate to the community. While the Bureau has an obligation to protect staff and inmates in Bureau custody, we also have an obligation to protect the public. This person's no danger to the public, but this is the Bureau of Prisons. The Bureau of Prisons does the best we can to minimize the risk of COVID to those in our custody, but it is imperative that as an agency, we also minimize the risk to the public. So, as you outlined in your letter to the General Counsel, Mr. Blank meets much of the criteria for home confinement consideration under the CARES Act. He meets all of it, okay? Now let's go on. However, contrary to your claim, the Correctional Programs Division has the authority to review Mr. Blank's suitability for placement in home confinement, as the warden determined there was a need to refer the case to the Correctional Programs Division for further review. In other words, had they never gotten this to the Correctional Programs Division, it would never have been on their radar. This is consistent with the April 13 Bureau of Prisons memorandum, which you reference. Specifically, the decision by this office to deny home confinement in Mr. Blank's case is based on the totality of the circumstances involved. Of significance, the court imposed a 21-month sentence on July 21st, 2020, well into the pandemic. Very important criteria there for somebody that's considering asking for special consideration. Because the Correctional Program Division is going to say, well, if the judge imposed the sentence during the pandemic, the judge knew all of this and there's nothing new. So please take that into your mindset if you're thinking or contemplating applying outside of the time frame. Now, of significance, the court imposed the 21-month sentence on July 21st, well into the pandemic. As I said, at that time, the court was aware of Mr. Blank's medical conditions. Remember to take that into consideration. And the history is outlined in the PSR. Take that into consideration. The court also permitted Mr. Blank to delay his voluntary surrender until November the 30th. Finally, it should be noted that Mr. Blank received an enhancement based on his organized or leadership role of criminal activity that involved 5 or more people or was extensive. These factors, when considered together, demonstrate that Mr. Blank is not a suitable candidate for home confinement. Now, here's where I'm just going to give you some commentary. You can get all of this information on this memorandum. I publish it in its entirety, but with the blanks on the website under that section. But I just want you to take this into consideration as you're moving into the journey, because it is a big bureaucracy. And you've got to know where the levers are that are going to open the opportunities for your earliest level of liberty at the soonest possible time. If you don't know those levers and what happens when you pull those levers, this goes into the right decision at the wrong time is the wrong decision, okay? It's the right decision to put yourself in a position to get a better outcome. But you've got to exercise discretion at the right time, because otherwise you got to know what's coming. I mean, is it possible to get out on a special circumstance? Yes, it is. But you'd better have a bulletproof reason. And that bulletproof reason, to assess whether it's a bulletproof reason, you've got to be thinking about the journey ahead. You've got to be thinking about if I pull that lever, what opens up over here? If I don't know that, I'm not making a good decision. And if I don't share that with as members of our community, I'm not doing my job. I am Michael Santos. I served 26 years in federal prisons of every security level, and I really understand how important it is to build a self-advocacy campaign. It's more important than ever during the First Step Act, ever. But if you don't get it, you can put yourself in a bad position like this person struggled with. And this person is a very close friend of mine. He's a big sponsor of our programs, and it sickens me to see this happen. But I understand this system, and I wish that I could have changed the outcome, but I can't. Nobody can. Nobody can change the past. Nobody can change the fact that you're in this system. What you can do is put yourself in a position to get the best possible outcome. And that's the information we want to provide, our team wants to provide at Prison Professors. We are a nonprofit. You get everything you want for free right here. You just got to be willing to do the work. And I hope that you found some value in this message. If you're watching us on YouTube, please do subscribe. If you're listening on iTunes, please do subscribe. But I do recommend that you become a part of our community. It doesn't cost you a penny, but educate yourself. Nobody should work harder for your liberty than you. And we provide all the tools to do that here. We're very grateful to our sponsors at White Collar Advice who assist us with these efforts. They sponsor this program, and they allow us to work to help people be the change that they want to see in the world. That's what I am doing. I am Michael Santos. I believe in you, and I'm wishing you the best on your journey. Thanks.